Okay. Here this is. I will not be able to see other people, so just interrupt me. Nothing I say in this presentation is legal advice. This is simply information. Please contact a lawyer for your client's legal needs. Outline. So I will talk about what options there are for somebody experiencing family violence. We'll go into what a protection order is, what the new rules are, and how things have changed. So while the forms are different and a lot more detailed, the information required and the evidence required and all the questions we ask our clients are all the same. And just the outlook is different. We'll discuss protection orders in general. If we have time, I'll get into conduct orders, exclusive occupancy orders, and how support people can assist. But we'll see how far we get. Key terms from the Family Law Act. So family violence, the definition is very expansive. It talks about physical abuse, which is what we all think about, sexual abuse, physical attempts to physically or sexually abuse. The one that I wanted to highlight is the one that I have underlined. It's the psychological or emotional abuse of a family member. I recently had an advocate or a support worker contact me and say that her client's ex said to her that, oh, how would you feel if you never see the children again? You know, what if I run away with the children? Ha ha ha, and you never see them. And then he lays out this plan, and it's very disturbing. And there are reasons to believe that he can leave, and he may not. But I think that in and of itself warrants action. So if it's psychological abuse, if it's emotional abuse, all of that can warrant action. It's ideal if there's something in writing to prove it, but even if not, the client's affidavit is the evidence, right? So just because there's no physical evidence doesn't mean there's no evidence. So I just wanted to flag that I don't want people to be discouraged. I want people to at least get their client's lawyer consultation so they can look at the evidence and then decide. And ideally a lawyer who has experience in women leaving abusive relationships and working with women leaving abusive relationships.
And Taruna, one thing I have noticed is that a lot of time the women, they especially at Harmony House, what we see a lot of new immigrant women, right? And for them, when they're telling this story, sometimes you have to ask and take those questions because they really undermine that, right? It's just, so.
Yeah, no, that's a very good point. When you ask women, has he been abusive?
Yeah.
In most countries, it's physical abuse. So they'll just say, well, no, he's never hit me.
Right.
But, and women forget that he grabbed their arm and the children were there or they were carrying the kids. And yeah, especially emotional abuse, you minimize it to stay in the relationship. Thanks, Neena. The definition of family member is also very expansive. It includes your spouse or former spouse, but includes anybody else you're living with. So people who live in joint families, it includes the mother-in-law, it includes everybody else, which my primary work was with East Indian women. And I think, Neena, a lot of your clientele happens to be of East Indian origin too. And all of these things came up quite frequently. I won't read the section number. Does everybody know? I guess you're all on silent. But when you're looking at definitions of these terms, it's the very first thing in the Family Law Act is the definition section. The act is easy enough to navigate. Some terms are still legal and jargony, like guardianship and all of that. But if you look, you can find definitions right at the beginning. So that's very helpful, I find. Okay. What options are there for somebody experiencing family violence? Family violence is relevant in the determination of best interest of child when making parenting arrangement. Even if the violence is directed at the spouse, Family Law Act does recognize that it can be harmful to a child. So if a mom has been abused in front of the child, that is recognized as violence towards the child. It requires explaining and proving to a judge that this is abuse for the child also, but it's there. Clients experiencing family violence can apply for a protection order in either level of court, and the protection order is police enforceable. So if there's a breach, you can call the police and they are supposed to show up. It's good to have a copy of the order. There is a registry where the police can look up the protection orders, but in an ideal world, somebody would have at least a copy of it. And the opposing party has to be served with it ahead of time in order for the police to be able to enforce it. Like say there's a protection order against somebody's spouse, but they never served him with it. And then he shows up to the house. You can't really claim breach. You didn't know this order existed. So people do need to be served. And you can get orders to ask a sheriff to serve them. But that's, if you're struggling with the service piece, contact me and I can elaborate on that. You can get peace bonds, conduct orders, criminal charges. Conduct orders are sort of the next level down. So if you aren't successful with a protection order, you can then ask for a conduct order, things like, can be anything. Parties will only communicate in writing about the children. They will not enter each other's home when they're doing pickups and drop-offs. And these things don't require culpability. Like they don't require you to quite prove that there was abuse in the relationship to the same extent, It's very valid for me to say, I don't want my ex in my house. And it's very valid for, the man to say, I don't want her in my house when we're doing pickup drop-offs and that sort of thing. Also depends on how old the kids are. You kind of have to work with the client, but one good strategy always is to recommend, perhaps you can't recommend it. You can't give legal advice, but suggest to the client to talk to the lawyer about a clause in there that says they'll only communicate in writing about the children. It just, at the very least, minimizes communication. He can't phone her 1,800 times. Whatever they're doing is now documented. So fine, I'm not saying fine, harass her, but if he is harassing her, it's documented. I'll get into peace bond on criminal charges. Okay.
Neena, there is a question for you.
Yeah.
The question is, how if mom is a victim of violence and not employed? Can she get the custody of the children?
Oh, so much goes into this. So if she would ask for parenting time, and if she can prove abuse to that extent and show that the dad was abusive towards the children also, then maybe he's still going to have some parenting time. I think in that situation with the mom, you talk to the client about what's important. So maybe she wants to make decisions about school. Maybe she wants to make all the important decisions, but she's okay to share, say, decisions about religion. She's okay to have, share other parenting responsibilities. So if you pick one or two and you only ask for those responsibilities and all the important day-to-day ones, again, to minimize communication, that's possible. Depends on each situation whether she can get full parenting time. That's hard to say. Just because there's abuse does not mean the children don't see the dad. How about that?
Taruna, there is another question.
Yeah.
I'm wondering how best to support a client who has been a victim of psychological violence over a long period, but does not live with the abusive partner. He accesses her through social media, text, or other family members. None of this is reported to the police, so there is no real record of the abuse. When she has gone to the police, they ask why she hasn't reported this sooner. How best to proceed in this kind of situation?
Neena?
I know it's tough, but I think the best thing as a support worker, what we can do is when she is going to the police, just accompany her, just be there. And like a lot of time, these police officers or the law enforcement officers, they don't really understand the trauma. So, just showing them, going through that lens and just really advocating for her. If she can journal, just writing down and have it, just written down what he's done. Any pictures, screenshots of the social media stuff, they should, and really, speaking with an officer and saying, this is, as a worker, just really advocating for her.
I really like the piece about journaling. That is evidence.
Right.
She may not have reported it to the police before, but if she's writing down each time he's harassing her, that is evidence. And people get to have privacy on social media. Now she can restrict it so he can't view things. And have a conversation with the friends and family members not to entertain their connection. So I don't know how much friends and family members know, but if they're facilitating connection, maybe they're thinking, oh, the parties want to get back together. But maybe she can just let them know, no, I don't want to. He's been very difficult to deal with. He's been abusive. Please don't tell him anything about me. Just having that conversation, I think most people will listen. And then, yeah, supporting her when she goes to the police. At least then they know you're involved also.
And also, Taruna, the other thing is just keep, don't give up. Like sometimes you might have to go a few times and just keep just doing it, right? So.
And the same with the protection order breach. Sometimes when the women call the police, they don't always show up. That doesn't mean you stop calling. You still call. And as a worker, you still advise them to call. And then they'll eventually listen. You can't give up. And same with accessing community resources. You can't give up, which is where as a support worker, you're integral because the client just feels like, well, I'm done. It's an uphill battle. But you're there to do the hand holding and say, no, we need to do this. This is unfortunately a part of the process. Okay. My screen sharing. Where did it go?
Thank you, Taruna and Neena. There is a comment in the chat for holding questions to the end. Okay. All I can try is I can take a few questions and then interrupt the speaker because they both like to answer the questions as the presentation is going along. So I'll wait for 4 or 5 questions and then I will interrupt them.
Yeah.
Otherwise we won't be able to, I think, finish.
Yeah. Okay, thank you. People can still see my screen, right?
Not yet. Can you reshare your PowerPoint?
Okay.
All right, looks good.
Okay, awesome. Legislative intent of protection orders. The point of the FLA in general was for it to be accessible, clear, and effective. And that was also the point of the changes in the forms. The form that you now use for protection order is a lot more detail, asks a lot more questions, which is great in some ways in that it tells people where, what to focus on. But a lot of the questions seem repetitive, and every time I'm reviewing someone's form, I think people think, well, I've said that already. I don't need to say it again. But you really do need to paint a complete picture. So if you're saying, he was abusive in 95, I got a protection order, he disappeared for 10 years, came back in 2005, disappeared again, I got another protection order, he was violent again. Now he's back, he hasn't been violent, whatever the story is. Because generally there's a long history. Just make sure you're capturing the history of it. That is the abuse. People focus on the now, which is also important. But if there's been a history of violence, that also needs to be captured. And you can say, please see attached document, and you can elaborate on a separate piece of paper. Now, I'm not saying make it 20 pages, but really thoroughly capture the story. And the client may find it very traumatizing to do this, but the judge doesn't know. And unless you explain it, they will not know. And like Neena said, people minimize things. And you need to have it fleshed out in chronological order what happened. Okay. The Ministry of Justice anticipated criminal code breaches. So it makes the protection order criminally enforceable, which is great. The police just needs to show up. The problem is you're more likely to receive protection from the legal system if you're assaulted, threatened, etc., by a stranger than a family member, even though the law says that you can get the protection order against a family member. It's just harder to prove because you're not gathering the same data against a family member. Courts are granting very short protection orders. My very first protection order was this horrible abuse case, and this was like 7 years ago as a lawyer, and it was horrible, and I still remember the facts. And the protection order I was given was for 1 week because the judge said that I hadn't notified the other party. But of course I hadn't. If I notify him, he's going to show up and abuse her, and the whole point of this is to protect her. Anyway, this happens, then you go back for another appearance. And protection orders are valid for 1 year. So if they say nothing, they're only valid for 1 year. The only time they're valid longer is if there's an expiry date that is clearly stated for longer, or if you want an order to not expire, then it has to say this order does not expire. It can't, if it says nothing, it's 1 year from the date that it was granted. Proper service. You have to serve the opposing party. Anybody needs to be served with an order against them. You can't enforce it. The application that you're bringing to court has to be served to the other party. At some point, you have to give people notice and they have to be able to present a case for themselves. There's a lack of knowledge of protection orders in the criminal court systems. They truly don't know what a protection order in a family court is. So if you're working with, if the woman's complaining to the police, they may not know. They may genuinely not know. The Crown Counsel may genuinely not know. I know very little about criminal law. Nobody's trying to educate me on it, and I'm not trying to educate myself on it. I can barely keep up with all the changes in family law. I'm sure that's how criminal lawyers also feel and Crown Counsel also feel. So don't think they're deliberately sabotaging your case, just educate them. Lack of consistency on enforcement of protection orders. Sometimes the police don't show up and I don't know what to do about it other than to keep calling. And to let the woman know, don't let him in the house. Instances of police referring victims to peace officers even when peace bonds or to protection orders even when peace bonds are more suitable. Yeah, police just aren't sure. So your client will get a legal aid lawyer often if their protection is at issue, so get them a lawyer. No, when I was an advocate at Battered Women's Support Services before I became a lawyer. 80% of my job was helping people because they just don't know legal aid exists. So you help them, you gather their documents, you apply for legal aid. So if that's what you're spending your time doing, that's very well spent. Lack of enforcement, orders and breaches aren't taken seriously. That's just what's happening in the world. Protection orders are similar to criminal bail conditions or probation conditions in that a breach of protection order is criminally enforceable. Like I said, a family member can apply for a protection order. It can be a standalone remedy or a part of the family law proceeding in either court. A protection order application can be made by a person on behalf of an at-risk family member, so you can make an application for them. I would like to say I've used PO here because these are slides. Please don't use abbreviations when you're filling out forms for anything. Just use the complete word. When you're applying for a protection order, who can apply? A family member on their own behalf or another person on behalf of an at-risk family member. I've never done this application by another person. It generally is the woman herself. But if something like this comes up, contact me. Legal test. What you're proving is the family violence is likely to occur and that they're an at-risk family member. You have to be able to prove that this is a family member. So somebody who's afraid of their boyfriend and they're 16 and not living together, regardless of age, not living together, that is not a protection order issue. They're not a family member. They don't fit the definition. An at-risk family member is a person whose safety and security is or is likely at risk from family members. From family violence, to be for family violence carried out by a family member. We're basically making, the test is that it's not imminent as in it'll happen now, that you can't get a protection order for something that happened 10 years ago. Now, if violence happened 10 years ago, the person went to jail for 10 years, or 9 years, they've been out on probation, you've moved and they've managed to hunt you down. That is grounds to go back and ask for one. But if they disappeared 10 years ago and now they're out of jail and you don't know where you are, it's hard to get those kind of protection orders. Section 184 sets out a list of risk factors the courts must consider in determining whether to make a protection order. You're looking at these things, so they're looking at history of family violence. Was the family violence repetitive or escalating? It doesn't have to be progressively worse each time, but at least repetitive. A pattern of coercive and controlling behavior. Again, it doesn't have to be multiple instances of physical abuse as long as you can show some trends of emotional abuse, psychological, whatever that may be. Current status of the relationship, is there substance abuse or there financial problems, that sort of thing. An at-risk member's perception of risk for their own safety. So it doesn't have to be objective risk. It does, as long as she feels fearful and it's enough evidence to support it, that's fine. Any circumstance that may increase their vulnerability. Make a note of section 184, and just take a look at it. Matter. So if a file has a lot of abuse and it's been ongoing, you can ask for the same judge to be on this file. So every time you bring this application, the same judge will hear it. Now, the problem that causes is court dates, right? The judge, if they're not there at that court on that particular day, you're restricted, but you can certainly do that. You can prohibit a party from bringing multiple applications. You can seek orders where you're saying this party who's been bringing applications every time now has to seek the court permission to bring an application. So before your client even gets served, the opposing party has to go to a judge and say, I want to bring this application, and prove the merit of the application before they can even bring it. This creates another hurdle for them. Orders respecting dispute resolution, counseling, the children attend counseling without the father's permission, whatever the case may be, if he's anti-counseling. Orders respecting communications, orders restricting communications, residence, that you pay bill mortgage until whatever this issue is resolved. Sometimes the women have left the home and need to go back to gather their belongings. You can get that order. You can ask for a sheriff to supervise it. You can ask for the police to supervise it, whatever the case may be. Really, it's the logistics of what needs to happen to make this particular client's life work. You seek those orders. You can ask for other orders respecting conduct. You can enforce orders respecting conduct. You can say enforcement by fine. I have never had luck getting an order that is enforceable with a fine, but the Act allows for it. So if party X breaches this order, they have to pay $500 into the court or whatever. Like I said, I've never had luck. I know that these orders have been sought, so it's there.
Taruna, there are two questions on conduct orders.
Okay.
Can I ask you right now?
Of course, yes.
Okay, the first one is, can you ask for conduct orders within protection orders? Is the person keeps blasting clients to people or online, but aren't technically contacting them? So it's not a breach. Client just doesn't want him to do that since it's or he is abusive. I didn't understand the question, but it's around, can you ask for conduct orders within protection orders?
So protection orders has no direct or indirect communication. So if they're contacting the party through somebody else, that is still indirect communication. If they're talking about them on social media, that's indirect communication. Protection order is very broad. You can ask for things like, I wouldn't call them conduct orders. It would just be a part of a protection order that, you know, when the party is dropping the children off, he can be within the parameters of the building, for instance. And they can communicate in writing about the children. And that's an exception to the protection order, but it's all within the same bracket. I wouldn't confuse it and add too many other things to the protection order, because that will just increase the likelihood of the police not understanding it and not enforcing it. And I'm always ready to blame the police for everything, but I do think that the onus is also on us drafting the order to make it very clear and make it easy for other people to do their jobs. They can't restrict people's freedoms unless there's a court order telling them to. So if you carve out an order and then you have 2 pages of conduct, or if you have all these exceptions, the police just isn't going to enforce it. So I've always kept mine, I'll include the necessary terms, but keep them succinct. I hope that answers that question.
I hope so. Can see if it's clear. It's good. If you have any more further questions after this, please write them in chat, or you can raise your hand and ask. Are there any other ways to enforce conduct orders?
If they are breached, you document the breach and go back to court to either seek a financial penalty, you can get that drafted in, or to get a protection order if it creates a safety concern. But, it also depends on what the order is. Like, you can't get an order that says he will feed the children nutritious meals, or he will whatever. Like, sometimes you get an order to say that, oh, he's not going to speak ill of the mom in front of the children. Okay, but how do you enforce that? How do you prove a breach? How do you enforce that? So the order I would get in that case is, 1, to try to limit his parenting time, and 2, to get the children in counseling. I can get an order that nobody's going to speak ill of each other in front of the children, but really that's not enforceable. So let's just try to find something that mitigates that damage that's being done. And that would be counseling for the children so they understand what's happening, and limit the parenting time, just limit the exposure.
Thank you, Taruna. There is another question. How would a conduct order work where a mother cannot get counseling for her child because father refuses to allow him to be vaccinated? Child has special needs and cannot use social media and needs in-person counseling. No specialist counseling in person is currently available.
Okay, I'm not sure how the immunization ties in, but if the mom, you can get a court order to say the child can go for counseling without the father's permission, without the father's consent. And that order, then counseling centers, if there's a court order to say this, they'll follow it with just the mom. If they're not seeing people in person because the child is not immunized, you can get an order that the child can get immunized without the father's consent. Really, you can try to get these orders. I don't know what's happening with COVID immunizations and court orders. I don't know if they're ordering this, but you can try to manage it with conduct orders, the whole situation. Just, again, it's client specific, so I'm happy to talk to you about your particular client situation and which orders are needed. But again, try legal aid. Try getting your client legal aid if it's a legal aidable issue. Okay.
Thank you, Taruna. There is a question. What role do social workers play in situations like this, especially family violence?
This was one of my questions for Neena for later, so Neena can get to it now.
I guess, the role is, one, is the biggest support, right, for the client. Sometimes social workers are asked to write letters, to support if they have evidence, anything. I think that's the role they play. And also just keeping your client, just that I find a lot of time is the paperwork, right? Like writing these letters and putting everything. I think that's a huge support a women need. Getting all the evidence and information, right, Taruna? Isn't that, even as a lawyer, that's what you really struggle with, having all the stuff together? I think support worker or social workers can really be that, an anchor to hold them, getting all the stuff together, right?
Yeah, and honestly, I know it sounds so straightforward getting all these things together, but it is so important and it is so time consuming. That
it's very overwhelming for a lot of them, right? It's like going back into the whole trauma again and getting everything in writing.
And the support worker has been there longer, has a relationship with them. You can sit in a cozier room. I've worked with Neena before, and our office is always so warm and welcoming, and there are couches and there are, Neena will start with a meditation. There are ways to center the client that you can work on. That it's just hard with a lawyer who's either got limited set of hours or is billing by the hour to do. And I always, in my private practice, used to work with support workers and would say to them, if you can just make me a chronology, or if you can help gather these documents, that just saves I don't know, 10, 15 hours. Like affidavits can take 10 hours to draft depending on what the history of the file is. It just takes so long to get the information out of a client. And yeah, they're triggered, they're crying, really getting a chronology of things. And if the lawyer sends you an intake form, completing that ahead of time.
Right.
I used to offer to review people's intake forms. Nobody sent it to me. Okay. Conduct orders versus protection orders. Like I said, protection orders are enforceable in the criminal justice system. The conduct orders are civil court orders. Family law is a civil court system. It is not a protection order. You cannot call the police. Conduct orders are not police enforceable. It will not say that on the order itself. Protection orders expire. Conduct orders normally don't expire. You don't have to worry about a conduct order expiring and reapply. So it's, parties communicate in writing, that just goes, no reason to reapply. Enforcing conduct orders. A breach of a no conduct order can be used and converted into a protection order. I've been over this, so I'm going to go to the next slide. Okay. Closing windows. McKenzie Friend, support person. Self-represented litigants may bring a support person or McKenzie Friend into the courtroom. The person cannot speak on your behalf. They can, and this is where you're really helpful. You can take notes, you can organize document, you can make quiet suggestions. It's not a good idea to sit there and be, talking, but you can make notes, and just making notes for the client about what's happening. It's all overwhelming, and it's their life is dependent on this. Their just emotions are high. You cannot give legal advice or make submissions to the court. You should not be somebody who's a witness, who will be called as a witness later. McKenzie Friend should generally not be one of the children of the parties. Yeah, I'm really not a fan of people bringing their kids to court. I understand they don't have childcare always, but this is also where a support worker comes in, right? If you can offer that he can be with the child at that point, outside the court, whatever the case may be. I just don't want children who understand what's happening in court. I had a client who had to bring her baby to court once. Just no other support was available. I didn't know it was coming, or I would have brought a staff in to help care for the child. And she had to, and that was frankly more stressful for her. The baby didn't understand anything, but it was so stressful for her. There are provincial court support person guidelines that are available online. So take a look at them. How can you be an effective McKenzie Friend? Let people know they should not scowl. If you're in the gallery, if you see your client's witness in the gallery, ask them to wait in the hall. Really be there to make sure the client knows what's happening and provide the support that they need. The hand holding is so important. I know we say, I don't know. I feel like people don't give it the importance that it deserves. Your Honor, my name is such and such. I am the applicant in this matter. You can let the judge know that I'm requesting that this person be allowed to sit beside me, especially if they're self-representing. Say this to the court. Have the McKenzie Friend form ready. All judges know about this, but have that print out and say, look, this is my McKenzie Friend. They're just going to sit here and help me organize my documents. What if the client, oops, sorry. I can't even read, there's this, sorry. What if the client is seeking, I can't read this because there's a little black strip blocking it. Does anybody know how to, okay. I'm gonna skip the slide, you guys. I can't read the heading because there's a black strip blocking it and I can't view it. So you can get exclusive occupancy orders that the woman is going to stay in the house with the children. For the purpose of this section, family residence means that if it's owned or leased by one spouse, it's the ordinary residence. Court can make an order granting that a spouse have exclusive occupancy for a limited period of time, or that their property be stored there. Applications for exclusive occupancy can be brought without notice, often at the same time as protection order. So if she's bringing an application for protection and wants to remain in the house with the children, you can bring that order. That has to be in Supreme Court. All property stuff is Supreme Court. Court filing fees apply. You can apply for a fee waiver. It used to be called application for indigent status. I'm glad that word isn't used anymore. You can apply for a fee waiver, and if granted, the fee waiver is only valid for a year also. The legal test is continued cohabitation and practical impossibility. Courts take this very seriously. So if he's abusive, perhaps it is a practical impossibility, but is there a basement where this party can live and has a separate entrance, you can close the door, whatever the case may be. Courts aren't just going to kick somebody out of their house, right? It's a very serious order. And if so, on balance of convenience, which party should occupy this? Resources, so there's section 211, you can look at, there's intake, or not section 211, the line 211. There's intake at Rise Women's Legal Center, it's legal aid, access pro bono. I don't know how many of you know about, that is not correct. I'm the FASA lawyer, Rosanna was covering for me. Everything here defaults. Every time I enter the email address, it defaults to her name. Amici Curiae, I don't know how many of you know about Amici Curiae, but they complete forms for people who aren't able to complete their own forms, whether it's family law forms for death, court, or divorce, or whatever the case may be. They can help people complete that. I think they do residential tenancy and all kinds of things, but look up Amici Curiae and they'll be able to answer your questions. I'm just going to type in the chat my email address. Legalcenter.ca, send me an email. Rise FASA if you want to schedule a time to speak. That bit.ly is the link to my online calendar. Schedule a time to speak. That way we know we have a chunk of time and we're not just playing phone tag and not just playing email tag. Like I said, it's my job to speak with all of you about your client matters. What I cannot do is give direct advice to the client. Or indirect advice through you to the client. So if it's a situation where I feel like I'm giving advice to the client, then I will just tell you to get them to speak to a lawyer. Okay, that's everything. Does anybody have any questions?
There is a question. Just a second. With the exclusive occupancy portion, how would the rent or mortgage be decided when this occurs?
You make an application for what you want. The other party makes an application for what they want, and the judge decides. So if the woman isn't working and the man's traditionally been paying, then that is the likely outcome. But if he's going to continue to pay and doesn't have a way to pay for that and his accommodation, then you have to come up with some kind of solution.
Thank you, Taruna.
Thank you.